I have seen many cases where defendants in a criminal matter accepted a plea deal, a plea bargain, or a plea agreement without fully knowing what they were agreeing to. This is usually the case when it comes to those defendants who have a public defender rather than having a private attorney defending their case. Now, I'm not knocking the public defenders out there. They are doing the best they can with the limitations and resources they are given, and most have an unimaginable caseload. And public defenders are usually given a set number of hours they can use for any one case, and it is not a lot of hours. I have seen estimates that range from about 5 hours for a misdemeanor case and 9 hours for a felony case. Did you hear that? They get to spend a whopping 9 hours on a felony case. That's it. Obviously, if it is a higher level felony, they may get more hours, but they are very limited in what resources they can use on every single case. That is why I made this video where I will discuss what every defendant needs to know regarding plea agreements. First, let me state, I am not an attorney. I do not play one on YouTube or TV for that matter. None of my videos should ever be considered as legal advice. They are merely my opinions based on my experiences as a professional private investigator. This video is sponsored by OREP Insurance and Working PI Magazine. OREP is a leading provider of private investigator liability insurance. Visit orep.org for a quote today. Another quick fact that most people are not aware of either is how many cases actually end up settling with a plea deal. It is estimated that 95 to 98% of all cases end in a plea bargain. That is truly amazing. 95 to 98% of all criminal cases settle. Now, you may hear me say plea bargains, plea deals, and plea agreements. In essence, these are all the same. And when I use this terminology, it is interchangeable. There are also sentencing deals, bargains, and agreements, and we will discuss those too in a few moments. In most cases, the prosecution is going to build their case, then present your attorney with a proposed plea deal. They often like to call it a plea bargain as it sounds like you are getting the better part of the deal. But regardless of what they call it, they will usually go with a one-sided deal that leans towards a harsher sentence for you. Any good criminal defense attorney will know this too and will automatically have a counteroffer in mind before they ever get the plea deal from the prosecution. The first thing you need to know is that the plea deal is essentially a negotiated settlement for the case. Much like if you are getting sued in small claims court, the first thing the judge may do is ask you to go to arbitration and try to work it out without the court getting involved. Then if you reach an agreement, you can either drop the case altogether, or what happens in most cases, you ask the court to solidify the agreement so it has legal binding. Now, this is a very basic way of explaining it, but once you come to an agreement in a criminal matter, both sides, defense and prosecution, ask the court to accept that agreement. And once the court accepts it, well, it is pretty much set in stone. And that is how most cases settle without ever going to trial. What you need to be aware of is that the prosecution will start at one end of the spectrum and your attorney will usually start at the other. But both sides usually know what is most likely to be accepted by the court or not accepted by the court, so they try to stay as close to that middle ground as possible. Many times a plea agreement might look like this. You are charged with 3 felonies and 4 misdemeanors. If you plead guilty to the 2 highest felonies, they will drop the 3rd along with all the misdemeanors. Then your attorney may counter with something like this. You will plead guilty to the lowest felony and misdemeanor, and the rest get dropped. Then they go back and forth until something is agreeable to both sides. But many times, these discussions are done before you ever hear about it. So the first time you hear about it from your attorney, it's going to be something like this. They offered us this plea deal. I think this is more reasonable. What do you think? But you can't interject. You can't ask the attorney to go back with a different offer. They should tell you if they think it will be okay or not, and why so. A big thing to keep in mind is that this is not a continual process. The prosecution is not going to go back and forth for weeks and months. If they can't get a quick agreement, they will just ask it to be set over for trial and see what happens then. And based on my experience, most of those cases that are set for trial end up settling the day of trial. You see, at best, in most cases, you have a 50% chance of winning. You never know how the jury will react. You never know the exact outcome, and your attorney should let you know this. This is also why it is not uncommon for 2 or more trials to be set for the same time and the same day. The court knows that in all likelihood, if they have 3 trials set that day, that 2 of them will settle on a plea deal and not have to go to trial. Now, when you settle, once you come to an agreement, you must enter a plea based on that agreement. And once you plead guilty, you are, for all intents and purposes, waiving your constitutional right to have a trial. So when you enter that plea, the judge is going to ask you a lot of questions to make sure you understand what you're doing. They will ask questions to ascertain your understanding of the possible penalties. They will ask you questions to ensure you are not coerced, threatened, or promised anything by anyone. They will ask you questions regarding your mental competency and if you are satisfied with your legal representation in the matter. During this questioning, if you have any concerns about what you're going to plead guilty to, now is the time to bring it up to the court. There is usually no going back once you enter that plea, so make sure you are sure you know what you agree to. A guilty plea is a criminal conviction. It may be on your permanent record forever. It may have long-ranging consequences that many people don't think about. It could affect your immigration status. It could have employment consequences. It could affect the professional licenses you hold. It may affect your voting rights, driving privileges, right to own and bear firearms, and many other consequences. Now, the plea deal is not the end of it either. There is the sentencing, and most plea deals will also have a sentencing agreement too. But you have to keep in mind this one very important fact. The prosecution cannot guarantee a sentence. They can only recommend a sentence. The final sentence is up to the judge. In fact, the judge could choose not to accept the plea deal or the sentence deal. Most sentence deals will be made where the prosecution states to the court the understanding of the range of penalties that the court could apply based on the legislation about these charges. Then they make a recommendation. It might look something like this. Based on our plea agreement, if the defendant pleads guilty to the Class 3 felony as charged, the other charges will be dropped. The Class 3 felony charge can hold a sentence of up to 10 years in the Department of Corrections and 5 years of parole. Given the defendant's cooperation and lack of other criminal charges, we would recommend a sentence of 5 to 10 years of incarceration and 5 years parole thereafter. Then the defense will make a counter to the judge that looks something like this. Based on my client's total lack of prior criminal history, Your Honor, we would ask for 5 years of supervised probation rather than incarceration. Now, these are 2 drastically different requests, and in most cases, both sides may have an agreement as to requesting something in the middle. But in the end, it is entirely up to the judge. One other thing you have to remember, if you are considering taking on a plea deal, that once you plead guilty, in almost every circumstance, you are now giving up your rights to a trial and your rights to appeal the guilty plea. Now, if you're going to be going to small claims court, if you are suing someone or going to be sued, and you want to know more about that situation, then check out this video.